Okay, hello, John Dove here from the Advocacy Club. We've just had the October meeting of the Legal Advocacy Club, and tonight's session focused on civil submissions advocacy. So our members tried their hand at the application for a relief from sanctions. So I'm just going to share some general hints and tips in relation to this piece of advocacy. So as a general rule, with any form of civil advocacy or civil submissions advocacy, it's always courteous at the start just to ask the judge whether they have had sight of the full papers. And I think this is important for two reasons. Number one, it's just courteous to ask the judge that. But secondly, it's important from your point of view to know that the judge actually has the papers in front of them. They've read the papers and therefore they can follow along with what you're going to be saying. So at the start of your submissions, you want to set out a bit of a roadmap for the court. So within your first sentence or two, explain to the court what you're doing and what you're seeking. So in a case like this, explain to the court that you are seeking relief from sanctions, as the case may be. And also set out a roadmap as to where you're going. So in this instance, it might be just a very brief point just to say, I'm going to explore points 1, 2, and 3 of the test, given that there was a 3-stage test here. And then from there, you're effectively going to jump into your submissions and follow along with the skeleton argument that's been drafted. What I tend to do as well, and I think what's important, is you should be signposting each time that you go onto a different limb of the test, just so the court can follow along. And also you can point out to the court, well, I'm now going to address point 3 of the skeleton argument, which is, and explain that. So it just makes life nice and easy for your judges. As you go through each stage as well, you want to be explicit on what the law says and then applying that to the specifics of your problem. And I'll go over how that applies to this particular scenario in just a second. What you may find as well is you may find that you're going to be addressing certain parts of the bundle. And if you do that, you might say, I'd like, Judge, I'd like you to turn to page 5, paragraph 4 of the bundle. Wait for the judge to find that. Wait for them to follow along so it's nice and easy. There's no point you just talking as the judge is still flicking through, because they're not really going to be following along exactly with what you're saying. And if you are going to be reading any part of it, so for example, in this scenario, we had a couple of cases in there. You might be citing from the case. You might want to read part of the judgment. If you're going to do that, read it nice and slowly so it's easy for the judge to follow along. So you're going to go through each limb of the test, and you need to go through that in some detail with the court. So the first thing that we needed to consider in this case was whether the breach was serious or significant. So we dealt with this in our skeleton argument, hadn't we? So this was limb 1, which started at paragraph 3. So in this case, what you're effectively going to be saying is that given that the witness statements were served only a week late and that there was still a significant amount of time prior to the trial, you would be arguing that in the grand scheme of things, this is not a particularly significant breach. And of course, you were able to back that up with case law, because we included a case in there which indicated that a 36-day delay in like circumstances, you've got a case whereby effectively witness statements were served late, and the court has held that 36 days is neither serious nor significant. So you were able to rely upon that case law to sort of buttress your argument. The key argument really in this case then falls into your second limb, which is why the breach occurred. And effectively, there's been no malice nor laziness really in relation to this breach occurring. It's just been a series of unfortunate events. So given the instructions that you had in this bundle, you just need to take the court through those step by step, of course, being courteous as you do so, but just really explaining in very simple terms as to why this breach has occurred. And then lastly, as with most tests in law, you're asking the court to consider all the circumstances and ask that the case is dealt with justly. So once again, you're effectively going to be reiterating some of the points that you've highlighted previously. The key things in this case are going to be the fact that all other directions, save for this one, have been complied with. All the relevant rules have been followed, to really explain that to the court. And the key thing to remember with most civil applications, you can remind the court that when it comes to the interest of justice test, any prejudice can be dealt with by way of costs, effectively telling the court, please allow us this application. You can penalise us by making an adverse costs order. And it's just a way of getting home on that point. You then want to effectively conclude. So you've gone through the legal test and you want a conclusion. Once again, you're going to be reiterating to the court what it is that you want. I say this most weeks at the Advocacy Club, but the structure for most forms of public speaking, legal arguments, submissions, advocacy, etc., it's going to be something along the lines of a brief introduction, telling the court what you're going to tell them. Your main body, you're going through the main submissions, and then your conclusion, you're effectively reiterating what you've said. And the nice thing with a case like this, remind the court that if the court grants this application, grants those relief from sanctions, no party is going to be prejudiced. Okay, the witness statements have been served a week late, but in the grand scheme of things, there's still plenty of time before trial. There's no real prejudice to the other side, and it's a nice way of wrapping up your submissions. So those are the points I would make in terms of presentation. Just some other sort of basic presentation points and things that I talk about most weeks, but I'll reiterate them because they're particularly important. Remember your pace. Remember that you need to speak slowly. I'm somebody who, like most people, speaks fairly quickly. So when it comes to your legal submissions, just think about bringing the pace down. About 100, maybe 120 words per minute is appropriate. It's particularly important because speaking slowly allows the judge to absorb more of what you're saying. It's easier for the judge to take notes. And most importantly, a slow speaker sounds like an authoritative speaker. When you speak quickly, you seem rushed, you seem flustered, you seem confused. So speaking slowly makes you seem more authoritative and like you actually know what you're talking about. Remember that you can vary the pitch and pace as well. Okay, so this is civil submissions. You're not speaking to a jury here. You're speaking to a judge about, let's be frank, a relatively boring topic. But you can add a bit of life to this. You know, you don't have to have a really flat monotone voice throughout. You can vary the pitch. You can vary the pace throughout just to keep your submissions interesting and add a little bit of life to them. And I say this all the time, but I'll reiterate it again. One of the most powerful tools you've got is the pause. So when you've made your killer point, you make your significant point, add a pause. It just lets it sit there for a few seconds and really add some weight to that point. So those are just some hints and tips that I have to share, and I hope you found those helpful.